This is Professor Wes Porter, and we're talking about the rules of evidence and specifically the rule. Again, we always start with our definition under 801C, the most important definition that you'll learn in law school, an out-of-court statement for the truth of the matter asserted. We understand now that this definition, this belongs to the opponent. The opponent is the one that says objection, hearsay. The opponent is the one that argues the purported bad purpose of the proponent, saying that they're doing this for the wrong reasons. They're doing this to prove the statement that's in quotes, to prove the truth. And we talked a little bit in other videos about how the proponent might have a middle column here, a second pathway to say that these things are not hearsay defined. These are times when the rule makers have said, no, you may have your definition, opponent, you may have your out-of-court statement for truth of the matter asserted, but I have my own definition under 801D. I have a not hearsay path, a not hearsay definition. Times when the rule makers say, the not hearsay definition will trump. And then there's this last column, a third option, a third path, if you will, for the proponent to say, well, it might be definitional hearsay, it might be a out-of-court statement for the truth of the matter asserted, but an exception may apply. And these are specific instances when they may be able to, the proponent may be able to rely on an exception. We're going to talk first about 803, the exceptions in 803 that have reliability. And again, this is sort of a landscape. The top has to do with, this is what the opponent embraces. Every time you hear objection, hearsay in a courtroom, it is the opponent. It is the opponent stopping a proponent in their tracks, someone trying to do something, someone presenting evidence, presenting testimony, and they're doing their thing in court. They're asking questions of a witness. They're presenting documents. And the opponent, the one that was usually sitting down at the time, stands up and says, objection, hearsay. I embrace the definition 1, 2, 3. I embrace that this is an out-of-court statement for truth of the matter asserted. And Judge, if you let me over to sidebar, I will explain the same. So most of what we covered in hearsay has to do with the proponent's response. First the proponent can just say, no. Opponent, you say you have 1, 2, 3. You say you have the foundational requirements of this definition met. I say no. Maybe it's not out of court. Maybe it's not a statement, or more popularly, I, the proponent, am not offering this to prove the truth of the matter asserted. I don't have the bad purpose that you assume I do. And then we learned about that second pathway, not hearsay defined. The specific circumstances under 801D sometimes has to do with the declarant being on the witness stand and their prior statements. Other times, in a different video, we talked about statements by parties, statements offered against parties, statements by party opponents. This is when one side of the caption, the plaintiff, has said something outside of court, is the out-of-court declarant, and the defendant is the one presenting that statement in court, a statement that is said by a party and offered by a party opponent. And then you learned about the other subparts that could be when statements are attributed to parties. Well, this is that last pathway, the wonderful world of exceptions, the part that eats up our evidence courses and takes so much of our time under the hearsay instruction. But for me, is almost the least important. Least important in the sense that you must understand the definition. You must understand the arguments of the opponent and the proponent under the definition, really the top part of the sheet. And the exceptions, if you will, are just the rule makers' times when they said, in these circumstances, we're going to say it's reliable enough. The words and quotes are reliable enough. We don't need the other assurance. And look at some of these arguments that come up. This is really what the proponent will say. If you argue definition, opponent, I'm going to say it's not hearsay, it's not offered for the truth of the matter asserted most of the time. Instead, I offer it for some other purpose, like impeachment, effect on the hearer, circumstantial evidence, state of mind of the declarant. Maybe it's not hearsay defined under 801D, and we're going to talk about why, because why. For this last one, my suggestion is, you can almost say it may be hearsay. Jump right into the fact that we're talking about an exception here, Your Honor. So I'm not going to argue with the definition under 801C. I'm not going to argue as proponent that it's out of court or it's a statement or even my purpose for offering it for the truth. Instead, I'm going to say I have these specific circumstances. An exception applies. I teach my advocates to say it may be hearsay, but an exception applies. But you can certainly say, Your Honor, we have a hearsay exception, specifically excited utterance under 803.2, specifically statement made for purpose of medical diagnosis under 803.4. Be as specific as you can and make your way over to sidebar and talk about the foundational requirements that exception. And really, if we're talking about hearsay, we're always concerned with these two broad concepts, right? We're concerned overall with who are these people that are offering these statements? What is the sincerity level of the declarant? These people that we don't get to meet in trial because it's essentially other witnesses or other documents that are offering their quotes for them. The people we don't get to meet. We don't get to evaluate their sincerity. We don't get to evaluate as jurors their credibility, and that worries us. That's the purpose of hearsay. And really it comes down to when we don't get to meet the people, we have real reliability concerns as it relates to the statement. This statement that they're saying that someone out in the world said that we don't get to meet, I'm not sure whether we can rely on it. I'm not sure whether we can believe it. Is it reliable? So I want you to think about these hearsay exceptions are the rulemaker's attempt. Good attempt, bad attempt, we can argue. But they're the rulemaker's attempt to say these situations, when statements are said in these narrow situations, circumstances of the statement, we're basically saying it's reliable enough. Regardless of what comes out, these circumstances for this out-of-court statement from this out-of-court declarant are reliable enough. And in these circumstances, we don't need to meet the declarant. We're not interested in the sincerity of the declarant. It can be inferred from, these are some of the popular 803 exceptions. You've heard some of them. I can't stand some of the titles of these rules, but we have to live with what we're giving. The first two that you often hear, and this is very simply, our 911 calls. Think about broadly our 911 calls. Something happens, something tragic happens, we call 911 and we're reporting something. Oftentimes 911, the people that call in, the people that report, the people that essentially offer the first words about a situation don't become witnesses. Their quotes may be used. We may take things they've said out of court in statements and even statements that are offered for their truth, but sometimes they don't end up as witnesses. So they may be offering what the rulemakers call present sense impressions, almost spoken thoughts, contemporaneous thoughts describing what people see. That's what a present sense impression under 803.1 is. It's I am talking, I am saying something, I am describing something as I am in fact perceiving it. So you can imagine looking out your window, being on the phone with a friend, talking about something unrelated, and all of a sudden seeing something outside. Oh my goodness, I just saw a man break into a window of a car that's parked outside of my building. I'm watching it still go on. Now he's doing this, now he's doing that. You can see those statements, we say the circumstances of those statements. Someone who as the out-of-court declarant, is perceiving something as they're describing it with no opportunity for reflection. A real contemporaneous, almost no time passage type of statement. We say those circumstances are reliable enough. That statement is fine for its reliability challenges under hearsay, and it's fine that we don't meet that declarant. We don't need to evaluate the sincerity of that declarant because there's no opportunity for reflection. Now notice, very narrow circumstances that we're willing to say, forget about the hearsay definition that the opponent has just lodged, forget about objection hearsay. We, as the proponent, have another path. While it may be hearsay, an exception applies. This is a present sense impression, say the description, then the rule number, under 803.1. And by present sense impression, Your Honor, here we have a declarant describing something as they're perceiving it. We think those circumstances are reliable enough, and we think that we have enough sincerity, we don't need to meet the declarant. The same thing, I hate the title of this rule, excited utterances, but it's sort of historically part of our evidentiary history here, so we keep it. But it's really statements said while excited. I don't think they're actually utterances, they're statements, and the excited is the only operative part of the rule. So it's statements said while people are excited. This is the proverbial man running out of a burning building offering up statements at the time. We never get to meet that person. We maybe never get to interview him. Just someone has heard it. So it's an out-of-court statement. And imagine a different witness, not the person running out of the building. A different witness shows up at the witness stand. It says, you were standing outside the burning building, were you not? I was. Did you see a man run from the burning building? I did. Did he say anything? He did. Objection hearsay. See that? We are calling for a statement that is absolutely out of court. It's going to be a statement, and we assume that the proponent's going to offer it for the truth of the very words that come out of that man running out of the burning building's mouth. What did he say? Your Honor, while this may be hearsay, may be an out-of-court statement for the truth of the matter asserted, I am offering it as an excited utterance at this time. I am offering it as someone that was absolutely excited. They were running from a burning building, no issue there. And the statement itself, I can't believe Bob finally did this, was about the excited event. This hearsay exception, 8032, for excited utterances has two foundational requirements. That the statement was said while the person was excited, and the statement related to was about the excited event. So long as the proponent can meet those two circumstances, those very specific circumstances, the definition doesn't matter anymore. We've found an exception. And notice the important thing here. When it goes back to the opponent, I'm the one that says objection hearsay. I've embraced the definition under 801C. I'm ready to say this is out of court, this is a statement, and they, the bad guys, the proponent, are offering this for the truth of the matter asserted. As soon as the proponent goes down this road, as soon as they say no, an exception applies. No, we're talking about an 8031 or an 8032 exception, present sense impressions or excited utterances, the conversation narrows. Now when the judge turns back to me and says, counsel, you don't go back to the definition. You don't say this is still out of court or they're still doing it for truth of matter asserted. You now say they're relying on an exception, they're relying on a rule, they're relying on 8032 excited utterances. I have to say that exception doesn't apply. I have to talk about how they have not met, the proponent has not met the foundational requirements under that rule. And this applies for all the hearsay exceptions, particularly those under 803. The proponent embraces the foundational requirements of the exception and then has to prove why they've met these limited circumstances where we don't worry about the reliability of the statement or we don't worry about meeting the declarant in their sincerity.